our board president to do this, because it forced me to actually take a look at things and to educate myself so that hopefully I could pass some information on to everyone else here. So if you want further information about the Divorce Act amendments, if you want to go dive a little deeper, if you go into the Justice Canada website under family law, you'll find quite a lot of information outlining in more detail the changes that are coming. But hopefully today I can at least give you a nice overview, and then from there you can take whatever time you want to flesh that out. So if you want to go ahead and move to the next slide. So really, when you take a look at the legislation here, there's not, you're not going to see anything that's revolutionary. Really what the changes do is they essentially incorporate a lot of, the things that already exist in some of the provincial legislation dealing with family law. And also, yeah, sorry, I'm getting some feedback. I can hear some people, so perhaps if you can mute.
Yeah, I'm gonna try to go through and mute people, but if you're listening, can you please mute yourself, and then because we are getting a lot of noise here, but I will go through and I'll go in three. I can tell who the offenders are. So
well, there you go.
Quickly, I'm coming down for you.
So really the changes incorporate things that are already in place in a lot of provincial legislation across the country. It also incorporates some of the processes that you find in our Ontario rules of procedure, as well as some of the other provincial court rules. It tries to incorporate some elements from existing case law, again, to try and clarify the law and help
make it work. Okay.
And hopefully make things work. And also, they have listened to a lot of the social science concerns that many of you will be familiar, that have been outgoing for for quite some time. So I see this as a positive step. Like I said, it's not going to be revolutionary, but it is nice to see the federal government recognize all of those things and try to come up with a piece of legislation that's much more child-centered and much more in tune with what practitioners are trying to do. And so if you go through the legislation and the material behind it, you'll see that the four key legislative objectives are set out on the screen. Primarily, it's promoting the best interests of the child. It's addressing family violence. There's some related changes to the legislation dealing with the family enforcement process, and to help reduce child poverty. And it also is aiming to try to increase the accessibility and efficiency of Canada's family justice system. So next slide. So again, best interest of the child. Some of you will have remembered there was quite a debate a few years ago about whether or not there should be presumptions in place about parenting arrangements. And in fact, there was quite a lobbying effort by...
I'm having trouble hearing you. Sorry, there's a lot of feedback.
Talk about what things we're going to divide in the house. Sure, you take this, you take that. He's excited because I like decorating. He's like, you help me do this. And then we joke about... So we have times where we're actually talking about how kind of fun it is to have our own space, yeah, which is really weird. But
no,
then
it's not.
This morning where
no,
I just want to.
No, it's not. So, so the first piece is because the two of you still have a.
So I'm just waiting till we get the audios under control.
There's a huge number of people. I'm trying to figure out who's talking. There's a conversation going on. And it's so far everyone's muted, but I'm missing someone. So hang on for 1 second. Just let me scroll through the list. Look at the pretty picture. Imagine seeing those blossoms on the trees outside your window soon. Next weekend, it's going to be warm.
Marianne, you can mute everyone at once, right?
Everyone's muted. Oh yeah, hang on. Current and new participants. Who said that to me? Thank you very much for... Except for hang on, that means I've muted Janet. Hang on 1 second. Janet.
It might be easier that way.
Okay, Janet, I've now unmuted you. Yeah, so yes, I did unmute. I muted all. Janet, you are, can you talk now, Janet?
I certainly can. Can you hear me now?
Yes, I can.
Perfect.
Okay.
All right.
All right, thanks.
So many of you will remember a few years ago, there was quite a lobbying effort by some advocacy groups on behalf of fathers that were really trying to have a presumption in place in these amendments that would provide that, you know, the presumption was it should be a shared parenting arrangements unless there were particular elements that would be contraindicative of that. And so what has now happened in the legislation is in fact that there are no presumptions about what parenting arrangement is best. The primary consideration is exactly what we would, I think is appropriate, which is a child's safety, security, and well-being. Next slide, please. The other nice thing about the legislation is it actually incorporates for the first time a non-exhaustive list of factors that a court is supposed to consider when determining the best interest of a child. And obviously we've had some of those lists before in some of our provincial legislation. This is the first time we've had something comparable in the federal legislation. And of course, the lists are very similar. The language might be somewhat different. But of course, we're supposed to be looking at the child's particular needs, their ages and stages, the nature of the relationship with other people, you know, the parents' willingness to encourage contact with the other parent and other people in the child's life, the history of the care, you know, so what's been the arrangements prior to a separation, child's views and preferences when those can be determined. Next slide, please. As well as, you know, linguistic, cultural, religious, spiritual upbringing and heritage. And particularly whether there's an Indigenous heritage, plans that are being proposed by either side, and as well the ability and willingness of people who are able to meet the needs and to cooperate with each other. The courts are specifically required to consider any family violence, and they're also specifically required to consider any other civil or criminal proceedings, as well as any orders stemming from those proceedings, because that may be relevant to the child as well. So a little more extensive than the list we've seen before, but certainly things that all make sense in the context of a family separation. Next slide, please. So one of the most striking things that people notice is there's a change in terminology. So I don't know about the people online. I've been doing this for 27 years. So custody and access, you know, is the language that I was raised on. But now it's specifically talking about changing that language so that we're dealing with parenting orders, decision-making responsibilities, parenting time. The kind of language that mediators have actually been using for quite some time. It's much more neutral. It gets away from that paradigm of winners and losers. And we also there's some language in here to try to talk about, you know, instead of having access, you know, we're talking about parenting time regardless of the decision making. But if we've got an access situation where we've got a non-parent involved, so a grandparent or someone else significant that's been involved with the child, there's terms in the new legislation to deal with those circumstances and those claims, but we talk about it as being contact as opposed to access. Again, very neutralized language. Next slide, please. It also tries to address the very thorny and contentious issue of mobility. And again, the idea is to try to incorporate some of the concepts and the elements of the existing case law and try and clarify the law in a hope that it will minimize the need for litigation, or at least the extent of litigation. So when we're dealing with mobility, that there are specific duties now that are set out for parents. And parents who want to move have a specific requirement to give notice of the plans to the other parent. The idea being that people that are involved with a child and have a responsibility to the child need to know what's going on. I mean, common sense kinds of things, but as we all know in litigation, that always oftentimes doesn't happen. Obviously, that kind of a requirement to provide notice of moves can be modified if need be, if we've got a serious family violence issue and safety is a concern. It spells out a process for how to manage this kind of situation without necessarily forcing people into litigation. So for example, right now, if you've got a client who isn't a decision-making parent and they receive notice that the other parent is wanting to make a move and they want to object to that, they're really, the only thing that they can do is they can start a court application, put the other parent on notice that they're not agreeing to that, and now you've got litigation started. This section actually allows for another type of notice of objection to be provided to the decision-making parent that then kind of puts people on notice, but allows them to go into some other sort of consensual dispute resolution process if possible, and try to address the issue without having to immediately go into litigation. And it also talks about the burden of proof in certain circumstances, right? So if someone is wanting to make a change, you know, who's the one that's got to demonstrate that this is best for the child or not? And so it outlines some of those things to give some clarity to the law. Next slide, please. And again, in addition to the factors for best interests in general, the legislation outlines some specific factors to be additionally considered in the context of a mobility case. So things like the reason for the location, the impact, the amount of time a child spends with various people that are involved in parenting, whether the notice that was required was provided, you know, whether any prior orders or agreements specified geographic areas, the reasonableness of the proposal to relocate, and primarily whether people are actually complying with family law obligations. So as you're aware, one of the concerns in mobility cases is whether a parent is doing that deliberately to try and thwart the relationship between the parent and the other, the child and the other parent. And so that flavor comes through here. You know, the factors very much focus on making sure that the parent who is initiating this, you know, has followed the rules, is doing things appropriately. So that's a good thing, I think. Next slide, please. There is very specific terms within the new piece of legislation dealing with the issue of family violence. And in particular, it outlines a positive duty for the courts to consider. I'm sorry, I can't see my notes for a second. Oops. To consider the existence of any other court proceedings that may impact on or may be involved in any concerns about safety about the child or any of the parties. And the whole idea is that there needs to be more coordination, and it's reflected in this as far as court orders from various elements, so that you're not ending up in a situation where orders may inadvertently be acting at either cross purpose or be in some sort of a conflict. Next slide, please. So again, the legislation is helpful in that it spells out a specific definition of family violence, and it refers to conduct, even if that conduct doesn't constitute a criminal offense. And so it includes things that behavior that's violent, that's threatening, whether there's a pattern of coercive and controlling behavior, causes a person to fear for their safety, and either directly or indirectly exposes a child to that conduct. Next slide, please. It also gives a non-existent list of possible examples, things like physical abuse, forced confinement, sexual abuse, threats to kill or harm, harassment, stalking, failures to provide the necessaries of life, psychological abuse, financial abuse, threats or actual harm or killing of an animal. And we know that those are some of the things that even if the pattern of behavior hasn't gone quite to the extremes that some people think about when they think about family violence, some of these lesser things may be just as effective in intimidating people. And so, you know, there's that recognition, there's that broadening of our awareness of what might be considered family violence. Next slide, please. So in addressing the family violence, you know, this is a specific element that the courts are required to take into consideration in deciding the best interests. And again, they've, in addition to the general best interest factors, they've outlined a very specific list of factors for a court to consider when determining whether, you know, family violence should impact on the best parenting arrangement for the child. And so they're looking at things like the nature, seriousness, and frequency, the patterns, whether the child is directly or indirectly impacted, or whether the violence is actually directed at the child. The risk of harm from physical, emotional, or psychological abuse, compromise the safety of the child or other family members, whether the violence causes a child to fear for their safety or the safety of someone else, as well as whether or not an individual has taken or is taking any steps to try to to try to prevent the reoccurrence. So they're also looking at the efforts of a perpetrator to try to rehabilitate themselves and take that into consideration. Next slide, please. As I indicated, in addition to the amendments to the Divorce Act, there's also additional amendments to the Family Orders and Agreements Enforcement Assistance Act, as well as the Garnishment, Attachment, and Pension Diversion Act. Those amendments may not come into effect July 1st. They may take some time over the coming months to do that. And so I just want to alert people to these things. These the amendments are designed to try to increase the tools available to establish and enforce child support. We're aware of the efforts to have regular changes to child support amounts being done by more of an administrative process rather than people having to go back to court all the time. These amendments would expand those services, allow them to happen at various times rather than on an annual or a repetitive basis. It would also facilitate access to getting the necessary income information for support payors to help with determining the amounts of support. Next slide, please. Lastly, one of the goals was to try to make the family justice system more accessible and efficient. And so again, as I mentioned, they're trying to expand the administrative services that would allow routine changes to support orders to be made without the requirement to return to court. They would include, an expansion of the recalculation services available. But they also, and in here, I think this is really an important element, they include an obligation on legal advisors to encourage clients to use family dispute resolution processes. So those are specifically defined to be negotiation, mediation, or collaboration. And so those of us who practice in this area know that we already have an obligation to talk to clients about the possibility of reconciliation. That's Section 9 duty. Well, we're now also going to have an expanded duty to try to encourage clients whenever it's appropriate to not pursue litigation, but to pursue these other forms of dispute resolution. And lastly, as I pointed out before, some of the amendments are there to try to take the existing body of information we have and the elements on particular topics and codify them and clarify them with the goal of trying to minimize the need when people have to actually pursue litigation to resolve those issues. Next slide, please. So the application of these amendments, existing court orders and amendments and agreements will be valid after these changes come into effect. So it's not necessary to run out and change existing orders, but these new rules will apply to any current court applications that are currently in the works where the order is made after July 1st. It'll also apply to any new applications brought after July 1st or any motions to change brought after that date. And I should point out, I haven't seen anything that confirms that there's going to be any delay in the implementation beyond July 1st. I had heard a rumor that perhaps the implementation would be delayed because of the pandemic. I wasn't able to find any kind of credible source to confirm that. Everything on the government website still points to the July 1st implementation for these amendments. Next slide, please. Now, as I indicated, the advisors have positive duties. The legislation also specifically sets out duties for parents. So people who apply for court orders under the Divorce Act are going to have a positive duty to exercise their parenting time and their decision-making responsibilities in a manner consistent with the best interests of the child. They've got a positive duty to protect their children from conflict, and where appropriate to use the family dispute resolution processes. They've got an obligation or a duty to provide accurate and up-to-date information as required. And they've also got an obligation to comply with court orders. I mean, that again is, shouldn't be a surprise. Those are things that we kind of, as practitioners, take for granted that people are obligated to do. But I think it's very helpful for the public to actually have those kinds of things codified in the legislation. And I think it's just a positive aspect of this whole piece of legislation. Next slide, please. Okay, there you go. Any questions? And I think, Marianne, you'll have to unmute people so that they're able to ask the questions.
You know, I think there's some feedback already. I'm going to go to the chat. We have a huge number of people on, so I'm not going to unmute all of you. I believe you can still unmute yourselves as we're in a meeting style, but let me know. Somebody just type in the chat if you can't unmute yourself, and then I'll unmute everyone, and we'll give that a go and have a good time. But there is a question already from the participants, and it's about violence and the definition. So I can scroll back to that definition if you like. And that question is your question, Mary. You can also ask another question if I didn't get that one right. It was the definition of violence that you had asked a little bit earlier. Shall I scroll back to the definition of violence piece, Janet? Would that be helpful?
Yes, please. And just so you know, I did actually kill some trees. This is the proposed piece of legislation, so I printed it off and just to be diligent. So I can actually refer to those specific provisions if need be.
My question, am I unmuted?
You're unmuted now. So Mike, thank you for confirming you are able to unmute yourself. I thought so. Good to know. And Mary, you're talking?
So my question is, often I find there's some confusion with people that I come in contact with in the field between, let's say, duty to report, where we have in the Children, Youth, Family Act, Section 125, around children in need of protection. And then we have C78 that starts talking about family violence and children in respect to family violence. My question to you is there an overall definitive overall view of what would constitute a child in need of protection in respect to violence that matches the different provincial legislations?
That's a really good question, and I'm going to be perfectly honest and say I don't know. In preparation for today, I didn't go back and revisit the definitions that you see in those other particular sections and make a comparison of the two. So I don't know if there's anyone else that's involved in the webinar today that maybe would have a better answer for you.
Thank you.
Okay. That is a good question. And I think I'll just go through these slides again. And if people would like a copy of the slides, if you can just email me after the presentation, the chat goes rather quickly, just send me an email to director@oafm.on.ca. And we're also recording and putting on our website and on YouTube a copy of the presentation. So you'll be able to see it again if there's something that you missed here.
Okay. So Vay has a question.
Okay, can you unmute yourself, Vay?
Yes, I can unmute. Thank you for that. I have two questions. My first question is about, it wasn't addressed in the slides that I saw, but I have heard that there has been an enlarged understanding under the Divorce Act considering maximum parenting time or maximum access time, and that the legislation defines that maximum access time as not 50-50, that it's more ambiguous. I'm wondering if you have any information to share about maximum access time under the new legislation.
Maximum parenting time. I'm just taking a quick look. There's nothing in the definitions that specifically talk about, a definition of maximum parenting time. There's certainly some reference in here. Essentially, it's kind of the same concept as we already have, that we want to try to have, a very liberal arrangement where both parents have a maximum amount of time that may be appropriate under the circumstances. And so it really doesn't give any kind of finite amount of time. It kind of codifies that depending on all the other logistics that people have and all those other factors when they're taken into consideration, we want to try to make sure that both parents have as much time as makes some sense. But it doesn't, to my read of what I've gone through so far, I don't see anything that specifically codifies it or quantifies it as a particular amount of time.
Thank you. And if I could just have one other question, it's related to the change in terminology that you noted from custody to parenting time and access. I'm sorry, from custody to decision making and access and parenting time. Is there any policy related to that change, or is it purely terminological?
My understanding is it's purely terminological in the sense of trying to avoid all of the connotations that exist around the current custody and access language, and trying to, I guess, focus less upon the participants and focus more upon the child. So the read that I had from the background material and the legislation, it seems to be that the underlying philosophy is moving from less of a rights-based idea to a responsibilities-based idea. So it's not so much about the rights of the parents to whatever, rather the responsibilities to the child. And again, you know, those of us in the mediation world, that probably doesn't strike us as being an unusual concept, right? It seems to make a lot of sense.
Thank you.
I hope I'm not cutting in on anyone. I wrote out a chat, and for some reason I can't send it, and you're not receiving it when I click.
We can hear you, Andrea.
Oh, I'm sorry. I wrote out a chat, but for some reason when I click the usual way, it's not being sent. Do you mind?
Okay.
That's okay, ask your question.
Yeah.
Okay. Thank you very much. I've extended my knowledge because of what you just said today, although I did have some experience, a lot of experience in the new Divorce Act provisions. What I've never heard from anyone is, are there property changes or amendments, especially with the matrimonial home, which we have as provincial legislation, which I find very restrictive.
Yeah, well, of course, there's nothing in the Divorce Act dealing with property because you're right, jurisdictionally, that's a provincial area. So constitutionally, they don't have any jurisdiction to deal with property.
So it's not even mentioned then.
No.
Okay, thank you.
Okay.
Is there time for
Yes,
more?
of course, Mike. Yep.
Oh, we've actually got lots of time.
Okay, great. My question's related to the question that Vay brought up, and it might help if we go back to the slide that mentioned the change in terminology around custody and access, because I mean the slide went fairly quickly, so maybe I missed it there, but it looked to me like you were saying both custody and access were being. Oh no, there is decision making and parenting time to replace custody, and then yeah, my understanding was decision making was to replace custody, and parenting time to replace the term access. Is that?
I'm not sure it's as restrictive as that, to be perfectly honest with you. I think really what they're trying to look at is, you know, obviously the decision-making power is going to be either both people or one person, right?
Correct.
That's going to have to be it. But I think when they're talking about parenting time, they could be talking about the amount of time that the decision-making parent spends or the non-decision-making parent spends. So
Sure.
it's not quite a complete, you know, it doesn't quite translate. And if you like, I do have the specific definition here for under the Act for parenting time. It means the time that a child of the marriage spends in the care of a person referred to in subsection 16.1 sub 1, whether or not the child is physically with that person during the entire time. So it could be parenting time equivalent to access, or it could be parenting time being the time that the child is in the care of that decision-making parent, even if they're at daycare or school or something like that. That's a pretty broad definition.
And am I correct that a person could have parenting time even if the other person had all the decision-making responsibilities? I mean, it's been that way in the past.
Absolutely.
So am I correct then in saying that when we write our future MOUs, that we should not be using terms custody and access. We should be substituting instead these phrases, decision-making and parenting time. That's
That
great.
would be my recommendation. Yeah. In fact, I know Marianne and I talked about this ahead of time. I currently use that language in the documents that I'm drafting. You know, even if it's a council mediation, and I'm helping council to draft things, I'm still putting in parenting time and decision-making responsibility. I've been doing that for some time, and I think a fair number of people have done that as well.
Yeah, I've been doing that as well. On a related to that, around the question of again, Vay had asked a related question. I'm not so much asking about what's maximum time, but I am curious whether the 60-40 spread is still the range of time that allows people to be termed shared in terms, or joint in terms of their access. Is that still the same range?
It is, because that provision is found in the federal child support guidelines, and there's been no amendments to that piece of legislation. It's only the Divorce Act itself.
Okay, so if one of the parties, if they agree that one of the parties has more than 60% of the parenting time, how would we refer to that party? Is that still the primary access parent, or do you know what language we would want to use to the person who has more than 60%?
So if we were talking about parenting time,
Yes.
It doesn't specifically spell that out in any of these, this piece of legislation, because of course that's not talking specifically about the child support. But I would think in this case, if you're talking about a situation where it's not shared parenting, where you've got a primary parent, then I think that's probably the language you would use, right? Either the primary parent or the parent with the primary parenting time, or, you know, some kind of language along that way.
Okay, great. Thank you.
Thanks, Mike. Okay, so there's a few questions coming in the chat that I want to get to, and one person kindly answered Erica, but I did want to comment that, you know, Erica's asking, as a new mediator, why is property a different legislation or a different decision maker and not included in the Divorce Act? And there's an answer there for Erica, but I mean, it is just it's the province has jurisdiction over property, and the country has jurisdiction over everything else, essentially, right? Is that, why is that's different? And it's sort of it was something that puzzled me when I first learned it. I was very surprised.
It stems from the British North America Act. And so, trust me, I no more want to get into that topic than anyone wants to listen to me on that topic.
Okay.
So, but it stems from that very basic division of powers that was created back in 1867. And so, you know, property issues are provincial. And actually, both the Family Law Act and the Divorce Act, so the provincial and the federal legislation, both deal with the issues of support, because there are some overlaps there. But otherwise, you know, the federal government has the jurisdiction over marriages, which is why they have the power to deal with divorces, and the province has the power over the property. So
I learned that first as a young mediator when someone confused me because they said they had achieved a divorce, or they had been issued a divorce, but they hadn't dealt with property. And I still kind of wonder how that happened, because I understood that the judge issuing or approving the divorce would have to look at the agreement. But anyway, that was missing, and that's when I learned it. But excellent question, Erica. Thanks for asking it.
The only thing a judge has to look at on a divorce is whether or not the child support is in accordance with the guidelines.
That's it?
That's it. That's the only thing that they're mandated to make sure is done. And so it's certainly possible to have a divorce, which is simply a court order saying you're no longer legally married, without dealing with all of those other related issues. People sometimes just get confused with the language. I oftentimes get individuals coming in, they reference a divorce, meaning the whole package of
Right.
issues. When from a legal standpoint, a divorce is simply that court order that says you're no longer legally married.
So I talk to my clients about that and say, you know, the separation is like the work of the marriage, like ordering flowers, getting, you know, making sure the music is there, walking down the aisle, all that other good stuff is the work of separation, the work of getting married. And then when you go off to the side and sign the papers, that's equivalent to the divorce sort of proceedings. That's usually how I say it, so that people understand the work is really done usually in the separation process, and the divorce is, they're sort of just, you know,
A piece of paper, right?
this is the paper. And then Justice Whalen asks, has section S16(9) been left intact? Consideration of past conduct. And then also, what is the impact of the changes on section 16(10) regarding maximum contact? So this is coming up a lot, this question.
Okay, so okay. I have to say, in the copy that I printed off of the changes, it doesn't give me that concordance, and so 16 is now dealing with well, it's similar. 16 is the parenting order, so it's changed. Let me just take a quick scan. Maybe Marianne, if you want to talk about something else, and I'll see if there's any reference to prior conduct. I don't remember seeing anything when I was preparing for this, but I'll double check.
Double check. Okay. And so I know I'm going to get to the question. Mary, you had another question, and if you've just joined us, you can try to mute yourself. That would be great. And then there's a question about spousal support, and I think that I was gonna hazard a guess at an answer to that, Judith, but I'll wait. I think it's dealt with by the province. I think it's only child support that there could be some crossover with the.
No, there's actually spousal support in the Divorce Act too. So.
Oh, okay.
I didn't spend a lot of time on that one, only because I figured it was more the children's issues that people were concerned about.
Yeah. While you're looking there, Janet, I was pretty interested when you brought up the issue of family violence, including the threat to harm an animal or to actual harm to an animal. And I've been working on a webinar for our members with Humane Canada. So Humane Canada is going to come and speak to us on July 22nd on Speaker's Corner at 1. And we're going to really sort of explore the area of violence against animals and pets, and threats against violence and pets, and the intersection that is a predictor and a screener for family violence. So if you can join us for that, I think it's going to be a really good one. The other one that's really pertinent to this discussion is the Assaulted Women's Helpline is coming on May 27th, so later this month. And we're asking for your questions in advance to the Assaulted Women's Helpline. Sorry, I'm just going to admit people are still joining. We're going to ask for your questions in advance shortly by email, or if you're hearing me now and you want to ask a question to the Assaulted Women's Helpline, you can email me at director@oafm.on.ca and ask a question specifically in regards to what the Assaulted Women's Helpline can do for us as mediators. There's a lot they can do. We can work very closely with the Assaulted Women's Helpline to create a safety plan if we discover family violence that needs attention. And they're such a good resource. So that's May 27th. So a couple of good webinars coming up in relation to that. Lots of other chat. I'm just scrolling down. Okay. I'm trying to see if there's questions. Justice Whalen is giving history. Lovely, Justice Whalen, thank you for doing that. And then Samantha is asking a question about how would a couple who have been divorced several years be privy to the change of language described in the Divorce Act? And does this change impact couples who have not been married but are now separated? I would imagine, I think there's some advertising about the changes to the Divorce Act. It has definitely been in the news. Some of your clients, if you ask them, will have heard of the changes. And I think if language in regards to being a parent would apply to anyone who's a parent. So, you know, regardless of the status of their marriage or non-marriage.
Well, the only thing is the Divorce Act only applies to married spouses. So if you're a non-married spouse, a common law spouse, then it's going to be the language in the Family Law Act.
Yeah.
So then it would be relating back to that, and right now the language still talks about custody and access there, but who knows, the province may take steps to try and have everything coordinated.
Yeah.
Sorry, when I skimmed through the new section 16, I didn't find anything that talked about past conduct. And also when I was taking a look, this is probably why it looks like section 15 of the Act, and forgive me, I don't have a copy of the existing Divorce Act in front of me, but my recollection is section 15 is the support provisions. It's actually been repealed, or will be if the once the amendments come into effect.
Okay.
And section 16 are replaced by now a very lengthy section, and that's the one that talks about best interests of the child, factors to be considered, the family violence. Oh, I'm sorry, there is a past conduct. Subsection 5 says, in determining what is in the best interest of the child, the court shall not take into consideration the past conduct of any person unless the conduct is relevant to the exercise of their parenting time, decision-making, responsibility, or contact with the child under a contact order. So hopefully that answers your question, Justice Whalen. And for Vay, you talked about maximum parenting time. Subsection 6 simply talks about in allocating parenting time, the court shall give effect to the principle that a child should have as much time with each spouse as is considered consistent with the best interests of the child. So it doesn't quantify that. It just says in the context of everything.
Janet, I have a question about interviewing children.
Yes.
And the context of that question is, we know that C78 is trying to build a more holistic approach to the relationship between children and their parents and try to mirror as best as possible the familial relationship and not cause conflict. Now, we also know from C78 they're encouraging ADR, and they are specifically encouraging hearing the voice of the child.
Mm-hmm.
Historically in mediation, I don't think most of my colleagues, unless I'm an expert, we don't generally bring in the children and ask them to contribute to building a parenting plan, unless there's some extraordinary reasons why the parents want them to, and we might bring in someone that's trained to it. My question then is, do you anticipate this new holistic approach, foreseeing that we as mediators are going to pay more attention to hearing the voice of the child and bringing them in more often into the mediation room as we build a parenting plan?
Well, to be perfectly honest, I think that's likely going to be a personal choice depending upon the viewpoint of the mediator. So just to let you know, I don't have what I view are the skills or expertise to interview children, but I do have another colleague in my area, and so I have called on her at various times to conduct voice of the child reports when the parents I'm mediating with require that. And I've actually found it to be quite helpful in a lot of cases, particularly when parents have, they sincerely have the best interests at heart. They just disagree on how that is. Oftentimes it's getting, a kid's particular view and preference about a proposal for how they're going to spend their times that can get you past an impasse. So I guess it depends on individuals and how much they're prepared to actually follow through with that. I don't personally see that I'm going to have much of a difference in the way I approach things just because this change has come into effect. And certainly this isn't something new. It's a concept that's been out there for some time in any event.
Okay, thank you.
And Janet, there's another question in the chat from Carrie, and she's sort of asking, how does the voice of the child come into the courtroom? And and you've done a nice job of explaining in mediation what you do as a mediator. And there are the Office of the Children's Lawyer. There's the Voice of the Child report. There are things that I understand can be ordered. But do you want to talk a little bit more about that in the court setting?
Sure. Sure. I mean, the primary way in a court setting that you're going to get the views and preferences of the child is the involvement of the Office of the Children's Lawyer. That has to be done by court order. The office then has the discretion whether they're going to apply resources to that particular case or not. And if they do, the office then has a choice about whether they're going to appoint a social worker or a lawyer to deal with the situation. If they appoint a social worker, it's typically to do an investigative report. And so the social worker will meet with the parents, watch how they interact with the child, interview collaterals, basically try to find out as much information as they can, which then is provided to the parents and the counsel involved through an oral disclosure. And if that's not sufficient to help resolve the dispute, then they prepare a written report that is filed with the court and can be considered as evidence on any subsequent hearing. If it's a lawyer that's appointed, then really the lawyer is there appointed to take instructions from the child and then represent the child in court. And so it's through that instructing process that their views and preferences can be, identified. It's not the case, though, that the lawyer then can come and be a witness. They're simply there as the advocate for the child.
Janet?
Sorry?
I just wanted input. There's another way through the OCL because I work for them. There's a Voice of the Child, which is a 30-day turnover, which they can appoint a clinician to do it. And they just get, they meet with the child twice. They get the information on what their preferences are, and then they send it to the court with no recommendations.
Okay. So thank you, Marion, for clarifying that. I just don't happen to have anybody in our area that does the official ones. And I know the colleague I have is a social worker who does them, but she's only willing to do them in situations where people are not going to go to court. So I appreciate that clarification.
Mm-hmm.
I know that there are people, sorry, I just know there's people out there that are doing it privately too. You can request a social worker to do it. I've been approached once to do it, but it never came about to happen. But I know that there are people asking for it, for a social worker just to do that Voice of the Child 30-day recommendation. So it's an option if people want to pay for it.
Okay, thank you.
Right. Yeah. So it sounds like, I mean, it's interesting because there's differences between, in mediation, we have this maximum creativity and flexibility, and we're trying to work together with our colleagues to bring the child's voice into the room. And in court, they have some other, creative options as well. So it's neat to see that both, if you're in the court process or in mediation, that there's the opportunity for children to be heard. There's a question, and Justice Whalen is saying it's a very difficult area for both courts and the mediators, and I would agree with you. I think the sensitivity is, I really applaud all of us when we're speaking about this. Everyone talks very sensitively about the process of how you would bring the voice of the child in. I know there's mediation training available specifically in Voice of the Child. We've had speakers at conferences and more to come on that too. And Marianne's talking about the training that's available. And I wanted to bring up a question back to maximum contact. And Marty is just talking about how, if we're the word maximum contact, we're focusing on getting away from the mathematics of looking at parenting plans in terms of the minimum 60-40 and all that other good stuff, heads and beds things, and focusing on an effort to maximize contact with both parents in a home. I think that's what Marty's comment is. And then I wanted to mention there's some conversation about spousal support being a gendered issue and looking at access to justice and that sort of thing. And Judith, if you want to expand with a question on that, that would be great. And
there's just one thing I'd like to also comment on the 60-40 piece, because again, I agree that this is, we're trying to I think what the legislation is trying to do is to also do what mediators oftentimes do, which is to focus on the qualitative aspect of parenting time as opposed to the quantitative aspect. And so, when we get into the 60-40 split, because that's how the child support guidelines are designed to, change from the presumption of full table amount to some other amount based on a shared parenting arrangement. You also have to remember too that 60-40 split, although that's the way it's spelled out, just because you got to 61% doesn't guarantee that a court is going to absolutely change the process for dealing with the child support. They could still order the full table amount. I mean, so sometimes we need to look less at those fine little details and more of the bigger picture of what's really going on, what's really happening in this parenting arrangement, looking at the quality of the situation and not just the details as far as the quantity of time.
I think that's a really good point, Janet. I think that you have to look at, like, what does it look like after you've looked at the legal model and explored it and see what happens. If there is a situation where it's and I'll use numbers again just because for clarity, but it's say you have a 70-30 situation, rent is very high in the GTA. How can both parents have access to housing that would provide enough bedrooms for the children, et cetera? And then some flexibility can be explored in mediation around what to do. And so I think it's a very good point to think about, can you afford, to take your kids to a movie after this is all said and done? Like, what does life look like? And I find often in mediation, it's that fear of, it's really not going to be fun in my house if I've got this situation. And how can the parents work together to mitigate the financial worries that each other are facing? Someone's looking out for how do you become a part of the community of Voice of the Child. I believe there's training with Deborah Rodriguez, so you can look that up. And then Nigel wants to clarify that OCL counsel are not formally instructed, but I guess asked to communicate views and preferences. So a distinction there. And then Sherry.
And that may be correct. I was trying to distinguish between a situation. I know in the past, sometimes OCL lawyers, were perhaps expanding upon and providing their own kind of perspective on things, where now they're really just the advocate that's to communicate it. They're not intended to have any greater involvement, right? Where a social worker is also providing some recommendations, so they're able to provide some additional input based on what they've observed.
Right. Yeah. I think someone else wanted to ask a question, but go ahead. Is that you, Judith?
Yeah, for some reason I went on to full view of my own face and I really hate that. Hang on.
Okay, can't see you.
Tell me about it.
Well, how do I switch this back? I want to be able to see your faces. Oh my God. Okay.
Yeah.
I suddenly can't see anyone. Okay, whatever.
Go up to gallery view in the top right.
I see that. Okay, gallery view. Okay, I'm just going to speak. Part of my questions around spousal support was addressing what you were talking about, Marianne, around the financial picture of a home. Mm-hmm. And of course, having had Julie as my supervisor, the access to justice issues are always kind of prevalent in my mind as well. But spousal, I just wondered if there were any significant or other changes to spousal support considerations, because sometimes in a family that can really significantly affect a financial picture, and therefore the picture of stability for children's homes, and on if there are any issues around needing to have ongoing negotiation processes or even court processes that sometimes without adequate spousal support, that it's often women, not always, but can significantly hinder that access to justice and being able to, at least in part, pay for even unbundled services.
Mm-hmm. No, I'm not aware of any changes to spousal support at all.
Okay.
And I totally agree with people. I mean, Contino obviously is the case law, and in a shared parenting arrangement talks about trying to make sure that you've got comparable standards of living in the two households. And I refer to that often with people when we're dealing with it. But I'm also conscious of some of that, even if you don't have a shared parenting arrangement. Because, not only is there the fear of not having enough money to be able to meet your living expenses, but then the additional fear that if you can't do any kind of fun things, is that going to somehow impact on the parent-child relationship, right? And that's a valid fear. So I don't know how many of you and what resources you have to try and help calculate support amounts and try to work through that issue. Personally, I have a subscription to Divorce Mate. So the nice thing about those support calculations is that it allows you to drill down into the net disposable income. And if you, properly input the information as far as discretionary deductions from people's pay, as well as all the tax information, you can get a pretty accurate picture as to what money's really left in their pockets at the end of the month. And frankly, that's the most important issue in my mind when you're dealing with individuals. I just find my experience has been that too often, lawyers, judges, and people in the system, we tend to look at the big picture. We look at the, table amounts, but we don't actually see how that impacts on everyone's lives. And I think it's important that we, spend a little more time actually drilling down and seeing how that works. Again, to make sure that kids have appropriate living arrangements in both households, right? That we need to make sure that it's an appropriate balance. And I'm not saying that that's equal by any stretch, but just a balance in those considerations.
And I find, Janet, that, if you go through the budget exercise with families and
Yes.
get them to understand each other's budgets,
Needs.
and
Yep.
I have had some success getting through independent legal advice some reduction in the tabled amount of child support to account for, my most recent one was crackers and cheese, because every day the children came home to one parent's house. They worked a different shift, but they came home from 3:30 till 7:30. And so there was expenses because it was 3 boys, it was a ton of snacks. And we figured out what the snacks would be per day. And, we reduced the child support that he had to pay by the crackers and cheese money, and it passed through independent legal advice. That may be controversial, but it seemed to be a solution that actually worked so that they both could, have money to go see a movie, and it was a joint outcome that they both desired. So it went well. Obviously that's a controversial thing to move away from the tables in any respect, but I think we do have to be creative when the situation doesn't fall into what the tables are intending to do.
Mm-hmm.
Okay, so we're getting to the very end of almost 2 o'clock now. Yeah, I know it goes super fast, and I just wanted to thank you so much, Janet, for coming on and being so brave and answering questions from the likes of Justice
trying to answer.
Yeah, and I really appreciate the collaboration from the group too. And I look forward to seeing you again. The Assaulted Women's Helpline is on May 27th. So if you've got information or questions for Assaulted Women's Helpline, you can email me and I'll send out an ad for that very soon. So thank you so much. I really enjoyed it. You're getting a million thank yous. Great job. Very concise.
Yeah.
So I'll sign off now and look forward to seeing you again very soon. Thank you.
Thanks,
Thanks,
Jen.
everyone. Have a great day.
Thank you.
Thanks.
Bye-bye.
Okay, bye-bye.
Okay, bye-bye.
Bye.
Bye. Thanks a lot.
You're
Thanks.
welcome.
Bye.
Bye, Marianne.
Bye-bye. Bye-bye, Kim. Bye.